Good afternoon to everyone and the attendees for this very important session. You're in the business of creating and expressing your creative ideas, bringing them to market. So really glad that we could have this opportunity to meet with you today. So in the time that has been given to me, I really just want to capture for you very quickly this whole idea of intellectual property and why it is important for you to be aware of intellectual property and how to protect your intellectual property. And it's quite timely because next week is going to be celebrated as Intellectual Property Week in Jamaica. And next week, Wednesday, April 26th, is World Intellectual Property Day. So it's a very good season to be talking about intellectual property, which really is a way of describing the fruits of the mind, what comes out of your creative expressions. It can be protected. It's recognized that it has value. It is an asset. And there are means under the laws in Jamaica of protecting and ensuring that you can exploit or commercialize your creative expressions. Now, there are categories of intellectual property, and it is important to know the different genres, because sometimes persons kind of mix them up. They say they want to copyright a trademark, or they want to patent a trademark or their copyright. So we need to understand that the big area of law is intellectual property. And the area that we are in is copyright, Jamaican Copyright Licensing Agency. And I will very shortly say specifically what we do. But to understand the two big bodies under intellectual property are industrial property, which covers industrial design, patents, trademarks, and geographical indications. And then under the other big area of copyright and related rights, we're dealing with literary, artistic, musical, dramatic works, sound recordings, broadcast, and cable programs. So here are some just images to illustrate the areas. So industrial design has to do with aesthetic appearance of the product, whether it's your jewelry or your car or the chair or table. The patents has to do with the innovative invention of a product or a process. The trademarks, we know them, the LASCO, the NCD, the Scotia, or your particular branding that you're going to bring on the market. And geographical indications doing with special food products that have a particular linkage to the area in which they're produced. So what is intellectual property really all about? Just to say very quickly, it's really about recognizing that your creative expressions have value and that if you want to bring them to market, we want you to, because we want you to enhance social life and even the body of knowledge by sharing with us your innovative creative ideas, but recognizing that we want you to be able to make money or to commercialize the expression of your creative ideas. So IP is about creating a balance, giving the creator a period of time to protect and to market their works, but then also allowing the public access to use those works and to build those works after a period of time, and really to contribute to economic development and culture. And there was a study done in 2008, it's dated now, but just for an indicative value of how important the copyright sector, the creative arts sector is to the Jamaican economy, contributing almost 5% of GDP. So whether we're talking about music or drama or radio, television or dance, and all the support services that go around our music and literature businesses, it's very important to the economy, but also to the creators who are involved in creating these expressions. So just to recap, what falls under copyright, we're talking about literary works, so whether it is books, whether it's lyrics of songs, whether it is software. Artistic, we're talking about paintings and photographs and illustrations. Dramatic, not just plays, but also dance choreography. Think about what NDTC produces. Musical, we're talking about the sound composition, the rhythm, the sound recordings that brings together the words and the music, the broadcast through television and radio, and also cable programs. These kind of works can qualify for copyright protection. But here's the thing, it's not the idea that's protected or the concept that's protected, but it is the expression of the idea that is protected under copyright. Now, how do you protect copyright? Here's the thing, it's automatic once the work exists in a written or recorded form. So there's no requirement under law that you have to register your poem or register your story in order to have copyright protection. It's automatic once your idea exists in a recorded form. So I've taken the photograph of the sunset, or I've written down the lyrics, or I have recorded the song. It already has protection automatically because it's now in a tangible form. Make sure though that you label your work, you put your name, you put the date, April 2023, and the international symbol for copyright, which is the C inside of the closed circle. Now, not putting those various items doesn't mean that you don't have copyright, but it's very important that anybody coming into contact with this work, this recording, this CD, can see immediately who is claiming authorship and ownership of this work. Now, the question then follows is, well, how do I prove that I'm the author? Well, there's several ways. You can mail a copy of the work to yourself through the post office, registered mail, put the poem or the story in an envelope, seal it, put your name and address on the front, you go to the post office, you pay the fee, and when that envelope comes back to you, don't open it, keeping it sealed with the little registered slip. It's really a timestamp to show on such a date you mail this work to yourself and kept it enclosed should you ever have to go to court if somebody infringes, and that's a word meaning somebody has used your work without your permission. You would bring all the evidence to attach you with this work, with the creation of their work. JIPO, which is the government agency for the administration of intellectual property laws in Jamaica, they offer a voluntary deposit system where you would give them a digital copy of your work and they would, for a small fee, keep that digital copy and issue a certificate to use to say that on such and such a date, this person submitted a movie or a story by this title. They're not saying that you have copyright. They're not saying that you're the author, but they're simply attesting that this person by this name deposited a copy with us on such a date. And again, it's really just a timestamp. You are required under law, if you have published a book or music as a Jamaican, to deposit a copy of the work with the National Library of Jamaica, the NLJ, for historical, archival, heritage purposes, so that we build up the body of work of creative expressions by Jamaicans. And then if your work is on the market and persons may have access to purchase a copy of that book or that CD, then you can join one of the collective management organizations of which Jam Copy and Jams here today are a part. And we're going to share with you what we do. Then exercising copyright also means commercializing it, exploiting it. The market now comes to associate your name with this particular product. And then you can also, under the law, if it should happen, that somebody uses your work or takes your work without your permission, you can take legal action, whether criminal action or civil action. So I want you to note a distinction, though, when we talk about the author of the work and the owner of the work. It may be that you have written the story, written the book, but you don't want to exercise your rights. You can sell it to somebody else, or you can license it to someone else, which means they then become the copyright owner. They will then be able to take it to market and earn from the use of the work, but they must still retain your name, indicating that you are the author of the work. You must always be identified as the author of the work, even if you no longer own the economic rights or the copyright of the work. And what are those economic rights? Well, it's to copy the work, to issue it to the public, to have it performed, have it broadcast, make an adaptation, maybe translating it to another language, or having it available online, on a blog, on a website, being able to be accessed by the public at any time at their convenience. And the moral rights is being identified as the author, but also being able to object to anyone using your work in a way that you didn't intend it to be, or using a context or a situation or an environment that would be demeaning to you as an author, and it would take away or detract from the value of the work. So two types of rights, economic and moral rights. And just to say, how long does copyright last? Well, as long as you are alive, plus 95 years after you died. So before it used to be life plus 50, but there was a change to the law in 2015, but it only applies to Jamaica. The rest of the world is between 50 to 70 years, but you have rights over your work for as long as you're alive, plus 95 years after you died. But that means that you can pass on your copyright to your heirs or whoever you would want to enjoy the rights after you have passed on. So please make sure you make a will and you put down in writing in that will who you're passing on your assets, car, your land, your bank accounts, but also your copyright. So let's get into some more specifics. What do we do at Jam Copy? Well, the Copyright Act of Jamaica sets out what rights you have and how you gain these rights, but it also allows the public to be able to make copies of a work, but in an limited way for a very specific reason. For example, for research and private study purposes, or critiquing or reviewing a play or a book and reporting current events. If you use it for these reasons, then no one could say that you have infringed or used their work without your permission. It's fair dealing. But what happens when you're in a setting where you have to make multiple copies of the work, for example, at a school, an educational institution? What happens then? Because you could then be charged with infringing, making multiple copies. Well, this is where a collective management organization comes in. And there are 3 of us in Jamaica: Jam Copy, JAMS, and JCAP. We do basically the same work, that of representing the authors and the publishers or the creators of the works, but we have specializations. Whereas JAMS and JCAP deal with composers and authors and producers of music, Jam Copy deals with authors and publishers of the written word and of visual work. So we deal with the book writers, we deal with the publishers, we deal with the photographers and illustrators whose works appear in print. But we have the common focus of collectively acting on behalf of many, managing their copyright in Jamaica. And this cycle, which is common to us, is to get permission or to act on behalf of these authors and publishers or creators. We have relationships with our equivalents in other parts of the world. So what it means is that the Jamaican author and publisher is not only getting representation in Jamaica, but also internationally through their relationship with the local collective management organization, CMO. We then negotiate with users like a UCC, like a UTech, like a UWI, like a Shortwood Teachers College, like the government of Jamaica, like the Ministry of Education. And when they then agree, we give them a license to make limited copies of the works for their students, for the administrators in the office. And then that gives them legal permission to make those copies. We collect the fees, which we then pay out as royalties to our authors and publishers. And then by so, we're helping to build up a copyright compliant culture in Jamaica. So Jam Copy, we've been around since 1998. We're actually celebrating quarter of a century this year, 1998 to 2023. And to just show you some of our licensees, we have 34 in Jamaica, but also to let you know, as I said, because we have a relationship with our equivalents in the world, we are actually a satellite of an international network called the International Federation of Reproduction Rights Organizations. We are part of an international body as well as a local regional body. There are 5 of us in the Caribbean: Jamaica, Barbados, Trinidad and Tobago, Belize, and the Eastern Caribbean. So when we talk about making a copy of a work, it's very literally, back in the day before there was a photocopying machine, people copied things by hand. And so when we talk about a copy, we literally mean a copy, photocopy, scanning, downloading, uploading, typing, faxing, Xerox, literally making a copy, and even putting the work into another format: audio, braille, large print, electronically coded. Once you make a copy of the work, you need to get permission from the author, from the owner of the work. But because you might be using tons and tons of works from across the world, the UK, USA, Canada, Barbados, Nigeria, it's going to be time consuming, probably frustrating for you as a school to track down every single author or publisher of every single book that you're using or that is online. But this is where coming to the CMO like Jam Copy would help, because we then now are the bridge between you, the consumer, the user of the work, and the creator of the work. And so what we do is act on your behalf in going to those writers, to those authors and publishers, getting permission on your behalf, securing the license, you then get the legal permission to make those limited copies, those photocopies of the works, and then you won't be facing a charge of infringing work. So it's saving time, saving money, and you're avoiding legal suit. Now, just to say that the purpose of the license from JamCopy is giving legal access and permission to make limited copies of the works for the purpose of teaching and learning in the classroom. It does not replace buying the book. So it don't mean that getting a license from JamCopy mean that you can go photocopy the whole book. No, 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 no. If you need the whole book, you go buy the whole book. We don't want to take away from the authors and publishers earning. This is their livelihood. But we're recognizing that in the space of teaching and learning, you may need to copy 2 or 3 pages from this book, from another book, in order to create a course pack in order to facilitate teaching and learning. And remember, at the beginning, I said it's about creating a balance, recognizing the rights of the creator and their need to earn from the use of their works, but also recognizing the need for the public to have access to knowledge. Very quickly, just before I close, just to say some features of our license: you would be allowed to copy up to 10% of a work, or an entire newspaper article or page, or a single short story, article, poem, item of print, music, or artistic work from a book, or a chapter, which is 20% or less of a book. This is just a summary of some of the features from a JamCopy license. So just to say that we have a website and we're on social media. You can follow us on jamcopy.com, or follow us on YouTube or Twitter or Instagram. And also to say that next week, Wednesday, again, it's World IP Day. We're going to be having an amazing afternoon. We're going to be having some creators and writers. The theme this year for World Intellectual Property Day is Women and IP. And we're going to be having a power talk at 3 o'clock next week, Wednesday, with persons like Veronica Carnegie, Terry Carell Reed, Sharon Fox Mold, Velma Pollard, and Courtney Greaves. Maybe you read about Courtney. She's 11 years old and she won a number of awards for her poetry, a global competition she entered in. Veronica Carnegie is 92 years old and still writing. And I'm sure you know content creator Terry Carell Reed. So we will send out that Zoom link if you're interested in Aiden. And we hope that you'll be able to pop in for a few minutes next week, Wednesday, April 26th at 3 p.m. So I'm going to stop right here and then wait for the questions when we have our discussion in a little while. Thank you so much.
Thank you for the invitation, Ms. Davis. I'll definitely, to next week, Wednesday, you said at 3, Power Talk, huh? Terry Carreri, oh, that's a powerful group of people right there. I'm very interested. Sure, I would love to get that link for anyone else that's interested here as well. Okay, so that was the Jamaican licensing company, and she gave us a lot of insights. And as she said before, there are 3 different managing companies. JamCopy is one of them. JCAP is one of them, and JAMS. Uh, Funnily enough, we also have JAMS here, the Jamaica Music Society, which is currently, the presenter is Mr. Errol Mullins. Uh, Anytime I look at an article regarding JAMS, he's the one to be there. So it's a pleasure to have him here today. He is the general manager, former CEO of JAMS, and he definitely knows his stuff. I will say that much. So, Mr. Mullins, whenever you're ready.
Thanks, Aiden. Appreciate those kind words coming from you. Really appreciate it. Well, certainly good afternoon to your viewers, your audience that is tuned in. Really a pleasure to be on. Thanks for the invitation. I'm always very encouraged when I see a school, an institution, a learning institution take this kind of interest in intellectual property rights and copyright in particular. It's always very heartwarming because I think there is so much that can be done and achieved when our students are learning about this, so that by the time they hit the working world, this is not something that is new to them. And so it sometimes would make our jobs even easier as collecting societies, as licensing bodies, because there would be that sort of critical mass of persons out there with at least a level of understanding of what we do and a level of understanding of copyright laws. So I'm really happy about this. I certainly will be inviting the UCC come next year, February, during Reggae Month. We normally have a seminar, it's an annual Business of Music seminar. We had a fantastic one this year, and really good turnout. Just A-level presentations, top-notch presentations from persons locally and overseas. And so I really plan on extending an invitation to the UCC for our next go-around come February of next year. Excuse me. So Philippa has done a really excellent job of laying that groundwork for me, laying that foundation. So thankfully, I won't have to spend too much time focused on some of those details which I had captured in my presentation. I will be able to sort of launch off into my presentation, which I'm going to bring on screen. Let me see if I can get this. Right. So I trust that you're able to see my presentation and that you'll be able to follow along. So certainly I won't be spending too much time detailing those aspects that Philippa has so beautifully outlined so far. So I'm going to be skipping the initial slides, but in general, my presentation will be about just understanding copyright in music and how that feeds into the whole generation of royalties, how you make money from music to a large extent. We understand what copyright is already about. We understand that these are some of the areas that are covered by copyright protection, literary works, dramatic works, artistic works. And I'm just going to stop here for a moment. Sound recordings, and it's a very particular term that I'd love for you to take note of. Sound recordings as distinct from what we call musical works. So sound recordings in general is really just a complete work that the complete song that has now been recorded and mixed and mastered and then placed on the market, and which you currently enjoy daily, whether on radio or you're listening on Spotify, etc. So it's that final product that we call the sound recordings. And there is copyright in this complete product called a sound recording. And that copyright belongs to it's called the master right, and it belongs to typically the record producer and when we say record producer, yes, we're talking about someone who could be an individual, or it could be an entity, it could be a record label, right? It could also be an artist who is producing himself, he's producing his own music, yes? So the person who does all of that, making that investment in the creation and the production of sound recordings, the complete work, they own the master right to that work, which is separate and apart now from components of the sound recording. And components of the sound recording also benefit from copyright protection. So we're talking about the lyrics, for instance, as a component of that sound recording. We're talking about what Jamaicans love to call the rhythm, right? Which is the musical composition. So those are elements and parts of the sound recording which have protection. And we kind of call them, musical works in a sense. And don't hold me too tightly to that, because in some jurisdictions, the musical work excludes, for instance, the rhythm component, and it only relates to just the literary aspect of things, yes? But we're talking in the context of Jamaica and in some sense across our Caribbean region. So sound recordings and musical works, you'll come across those terms as we progress through this presentation here. But those are very identifiable components which have their own protection. Now, the crux of my presentation will focus around these particular rights. We call them the economic rights, and Philippus spoke of them earlier. These are the rights that are granted under the Copyright Act, yes, of Jamaica and elsewhere. Very specific rights. They are actually called exclusive rights also, meaning that the persons who hold these rights can permit or not permit the use of their work, yes? And so we'll start with number one, which is the right to make copies, to reproduce, or to make copies of the work. So you are the producer of a recording, and you therefore have the right to then make copies of that sound recording. And so that is the basis, for instance, on which a record label or a producer can enter into agreements. For instance, back in the day, you'd have Sonic Sounds and Dynamic Sounds and so forth, that were entities which were responsible for, had the role of manufacturing vinyl records, and then we transition to CDs. So this making of these copies, every single copy that is made would have been done under permission, because the person who owns that right, that right for copies to be made, should have granted permission for those copies to be made. And by the copies being made, the owner of this right is then able to benefit economically and financially from those copies that are made. Then there's a right to distribute. And so that's a separate right that persons have as creators and owners under the Copyright Act. So you make the music as a producer, or if you're an artist who's producing your own music, you then find a means to distribute your work or to have your work distributed. And this could be a book, yes, but we're going, or some other form of copyrighted content, but we're going to focus on music. So don't, you know, just walk with me as I speak more specifically just to music related items. And so we have the right to distribute. And that is why, for instance, a label would say, go to a VP Records, you know, back in that time when, you know, you had to, in a sense, have that type of distributor. But in more modern times, you know, there are a plethora of distributors and aggregators that you can go to. You can sit right where you are, in your studio, in your homes, etc., and you identify a distributor, and you grant them the right to distribute your work. And they then take your work, take your music, take your song to the retail platforms, the Spotifys, the Pandoras, the eMusic, the Yahoo Music, Amazon, and so forth. Those are the retailers, the online retailers. You still do have persons and companies that engage in physical sales. You have one or two stores here and there. I think we still do have Derek Harriot's operating in Halfway Tree, if I'm not mistaken. And also on South Avenue, there is Music Mart. So there is still some distribution taking place via these means. But for the most part, in our industry, locally and internationally, it's all about digital distribution. And so the right is granted for music to be distributed digitally and otherwise. There's also the right to what we call perform the music in public. We call it public performance. And this is a permission that you grant for music to be played in the clubs, to be played in the bars, in the supermarkets, and in the stores on the shopping mall, right? At a dance, at a party, a round robin, a drink out, etc. It's called a public performance. So once you take that music outside of your own personal or domestic circle, and it is now being played to an audience beyond that, it is considered under copyright law as public performance. And the owner of the right, you must have permission from the owner of the right to be playing it publicly. And typically a fee is involved in that process, which the CMO, the collecting societies, handle by giving a permit. And then we pass that on. So public performance is a huge part of what we do. Yes, and let's spend a second more on that. For public performance, you have a whole range of businesses that, of course, and events that engage in public performance on a daily or annual basis. In fact, in Jamaica, on an annual basis, there are over 20,000 events which take place. And that is just what comes through the formal system. And the vast majority of these events engage in the use of music, playing music. For our part, meaning jams, we represent the rights of the producers and the performers. And the rights of the producers and the performers really revolve around the use of the recorded work, meaning the songs that have been, made in the studio, mixed, mastered, and sent out. We do not grant license or permission on behalf of our members, those are the producers. We do not grant permission in relation to the live performances that are done on stage. So when we say public performance, from Jam's perspective, it's about the use of the recorded work. However, where JCAP is concerned, they represent songwriters and composers and publishers, and their right subsists or exists in the recorded work and also in the live performances, right? And so JCAP will be collecting a fee in relation to on-stage performances, because someone, Taurus Riley on stage, may be singing a song that he's not the writer of. He may be singing a cover version of a Michael Jackson song, which he actually did. And so JCAP grants a permit in relation to that event. And they would then be able to pass on to Michael Jackson's estate, once he's a writer, his share of royalties emanating from that actual performance, which involved the use of the lyrics that were penned by Michael Jackson. Then we come to broadcast. Broadcast, that's a separate category altogether that is protected and which has an exclusive right surrounding it. And this really speaks to the use of music by radio, television, cable operators, and so forth. All of these groups and entities that we're now referring to must have permission to be playing the music via this means. So the Fame FM, IRFM, the Zip FMs, Fire 105, all of these stations that you know and love, they actually do need a license to play the music legally, because the exclusive right belongs to the owners of the master. They belongs to the songwriters and so forth. They have these exclusive rights. And by being owners of these exclusive rights, they can prevent the use of the music on air. And there are different methods, of course, for enforcing these rights that we have available to us, which are used sometimes. And then there's the adaptation right. So Philippa spoke about that earlier. You can, translate the work probably into another language and so forth. And there's what we call the making available right. So you put it online on the blogs and so forth and so on. That is making the content available. You have that right, or you can restrict it as well. However, all of these are economic rights, which can therefore be exploited for financial gain. The moral rights were referred to earlier, so I won't go into that. And so as CMOs, really, our job is to act on behalf of our members. We're a members-based organization, which means that we act only on behalf of those who have granted us the authority to represent them. So not all CMOs function in this way, however. That is how we function. That is how the majority of CMOs function, where once you have given us that right, then certainly we're able to grant licenses on the behalf of the collective that we represent. And we negotiate rates and terms of use with end users. We issue the license, we collect and distribute the royalties, right? So that's the crux of what a collective management organization does. And of course, in Jamaica, we have JAMS and JCAP representing the music side of things, producers and performers JAMS, songwriters, composers, and publishers JCAP. But certainly across the world and elsewhere within the Caribbean, just so that you have a broader perspective. Within, say, Trinidad, there are actually multiple societies representing these same groups. Unlike Jamaica, Jamaica only allows one CMO, one collecting society, to represent a particular category or class of rights. So for instance, JCAP represents songwriters and composers and publishers. They are not allowed to also represent producers and performers. JAMS does producers and performers. We are not allowed to do songwriters and composers. And this sort of setup under the law is actually very useful. It's actually very efficient, because can you imagine having two CMOs doing the exact same thing, and not both of us trotting our way over to RJR or going to an event promoter or a club owner, trying to negotiate for our different groups of persons that we represent, but trying to collect for the exact same right. It's a very difficult situation, and it creates a lot of uncertainty within the marketplace. And sometimes the end users will say, you know what, I'm not paying anything because I don't know who to talk to, right? So that's normally an excuse that arises when you have that situation in a particular country. Within the Caribbean, Trinidad actually has that situation. They have COT and TTCO and another called Awesome, and they all, under the law, are able to represent all categories of rights owners. And so their market it's a little different, and you know it can be actually a difficult market to operate in as a CMO because of they're all doing the exact same thing, represent the same groups of rights owners, going to the same set of persons and end users. Within Barbados, there is a company called COSCAP. Only one CMO exists in Barbados, and that entity represents all categories of rights owners. And further afield within the Caribbean, there's ECCO, ECCO, and they represent and cover a range of Eastern Caribbean territories. And they, however, only cover songwriters, composers, publishers at the moment. They do not cover neighboring rights, which are the rights of producers and performers. And I mean, in simple terms, what are the benefits of a CMO? It really and truly eases the pain of having that individual attempting to go and negotiate on his own behalf. So you're the owner of all of these rights that were mentioned earlier. It's extremely difficult for you now to go out and try to negotiate on your behalf. Yes, you can do it, it's possible, but it's going to be very difficult and extremely expensive, very costly. You'd have to hire your own set of lawyers, your own accountants, and so forth to go engage in a negotiation with a media group, with a media house, with an event promoter. In fact, it becomes very impractical very fast because there are so many users of your music, your content, that you simply cannot get around to negotiating with everybody, and you stand to lose a lot, quite possibly, while costing you a whole lot. So you may arm yourself with lawyers and accountants only to find out that the promoter that uses your music only has $3,000 to give you, because that is your share of what was earned from that particular event, or $3,000 from broadcaster because your songs were played just a handful of times over a particular period. But you would have expended probably $350 per hour on legal fees. So the CMO model allows for us to handle the rights of many rights owners in a collective manner and sharing those costs across the board. So it's an extremely efficient model that has been around for decades. And thankfully, it is what works really well also here in Jamaica. All right. So who do we represent? I'm going to try and keep track of time as we go along. So let's pardon me while I do a time check. Right? Okay. So we represent producers and performers, and producers, as we mentioned earlier, could really be just an individual, typically an executive producer. Yeah. The person spending the money, the person who is taking on the risk, the financial risk of getting an artist in studio, booking studio time if they don't own their own studio, getting the musicians, paying the engineers, mixing engineers, recording engineer, mastering engineer, all of this. Music is not free. It costs to make music. And if it's going to be done right, it sometimes can cost quite a bit to get that quality that you're looking for. So music is not free. And there's typically someone behind the scene who has to come up with this money. It's not always just about the artist. In the vast majority of cases, globally, in terms of the music market, the artist really turns up and does his vocal performance and so forth, and then he leaves. It's the producer who must coordinate and bring all the elements together. And for that role that the producer play, meaning an individual or an entity, a record label, for that role that they play, the copyright laws grant them rights, rights to that sound recording master. Whereas the artist is not left out of the loop. The artist owns the right to his performance on the sound recording. The artist does not own the master right. The artist owns his performance, his vocal performance on the sound recording. And if he happens to be the songwriter, he therefore also owns his rights as a songwriter. So therefore that becomes two streams of royalties, two streams of rights and royalties for him or her, right? Right, and so I can jump over to performers. And this is where the artist comes in. So when we say performers, we're talking about the vocal performer. But we're also talking about who we call the musicians, the players of instruments. So you have the featured artists and the non-featured. And so this is another category that we also represent, artists and musicians, including backing vocalists as well, not just a featured performer, backing vocalists as well. And we cover performers in the international realm. Walk with me for a second. Although we have the mandate to represent producers and performers, we are constrained, have been constrained to represent performers in Jamaica because there still exists a gap in the law which does not allow for performers to earn when their works are used. So their remuneration rights does not exist for them in Jamaican copyright law yet. It is slowly, after much lobbying and advocacy and pushing and pulling, it is finally and almost there. We expect it to happen within short order, where the performers can also enjoy the same benefits as the producers and the songwriters and composers, right? So our work in relation to performers is done in the international space. And for that, we have a significant number of arrangements in place, which is covering over 40 territories across the world. You name it, in terms of all the major markets are covered: USA, UK, Germany, France, Australia, Japan, and so forth. Korea, Brazil, you name it. So we're covering the globe for producers and performers. And visually, this is what it looks like, right, whom we represent, right? Won't go over that bit, right? So I'm going to spend my last 5 minutes or so just speaking a bit on this, how you break those economic rights out into categories. The truth is there are really two broad categories: publishing rights and master rights. Remuneration rights sort of is a spin-off or a subset of the master rights, right? So I'm going to focus on publishing rights for a second. Publishing rights, you hear people talk all the while about owning their publishing and want somebody to represent them as a publisher. Is one of the most probably misused terms in our industry, publishing, because publishing actually has a fairly defined meaning. And I'm sure we have persons within our own audience here who are very aware and savvy at handling publishing matters. But publishing rights really are rights which belong to the actual creators, the original authors of the work. So the songwriter, right? Let's call him the lyricist for now. And the composer, let's call him the beat makers, just for simplicity. In other jurisdictions, you just say songwriter and you're covering both in one shot, right? So those persons who are creating that original work, they have what is called publishing rights, yes? Whereas in terms of the master rights, this is now something different. And that is now then controlled by the record labels, the record companies, the independent record producers, and self-producing artists. So that we're not talking now about those elements of the recording and who owns the rights to those. We're talking about the complete work, that recorded work, which has an owner. And the master right emanates from that complete work, right? And record labels are generally the ones who are most known to own master rights, but individuals do own it as well, including some artists. There's been a huge discussion raging over the last several years in particular, goes back decades, about artists wanting to own their master rights. Now let me make this clear and clear this up. Artists do not automatically own master rights. I said that earlier. They can own it, but it's not automatic. Typically, once they have agreed to record for a record company, a record label, or record producer, then it is those entities that own the master rights, unless there's an agreement otherwise. Right? If, however, you're an artist and you take on the time and the risk and the financial investment of making your own product, producing your own product, then you automatically own the master right there. And so you have Anita Baker, you have Prince, you have quite a number of these high-profile artists over the years who would have been attempting to claim their master rights, but in fact, it wasn't theirs to claim. They're attempting to claim the master right, not theirs, the master right. And but the US is a very different context, you know. And so after 35 years, for instance, in the US, once a record label would have signed an artist and that artist has recorded for them under certain conditions, after 35 years, that master right now gets passed on, or what is called reverted, to the artist or the original maker and owner of that work. So if you, for instance, had invested in the production of a single or an album, for instance, and a record company came to you and said, we want to license this work from you, and you do that, you're in that case the original owner of the master. You have, however, just licensed it or assigned it to this company. US laws allow for, after 35 years, for that master to revert to you under certain conditions. So this is a very important thing for us to note. Artists can certainly own their own master rights, but it is not automatic. Right? And the remuneration rights that we're speaking of typically relates to performance. It's called equitable remuneration rights in many jurisdictions. And their right, and the right that they have to earn is what I mentioned earlier, which does not exist in Jamaica. And so when a song is played, they have the right to earn from it in a similar fashion to the record producer or the record label or the songwriters and composers. And so when, say, a Tony Rebel song gets played in the UK market, for instance, he's able to earn from that. However, when that same song is played in Jamaica, he's not able to earn. And he earns because he has performed vocally on a song recording. So both the producer and the performer or performers, those two together, are known to have what is called the neighboring right. So the copyright normally is a term used and allocated to the songwriters and composers, their right, their body of rights. Whereas the producers and performers, you hear the term related rights or neighboring rights. It's still copyright, but it's a term that has been used over the years to kind of make a distinction between the rights of the producer and performer as distinct from songwriters and composers. And so even when we talk about performers, it's not just the vocalists. As we said, it's also the players of instrument, the backing vocalists, but it goes even a little deeper as I wrap up. It really speaks to, a performer really speaks to anybody, anyone who has made what we call an audible contribution to a recording. So if you clap in a recording or on a recording, you actually are able to earn royalties, right? By just contributing your tap tap or your clap clap, right? Something as simple as that. And there are mechanisms available within CMOs to ensure that even that minimal contribution, as some might think it is, that they get compensated. And we have many, many cases of this coming through jams on a daily basis, annual basis, when we see royalties coming in from all parts of the world for them, you know, once they have registered with us, right? So I think what am I doing with time, Eden? Yeah, not hearing Eden. So I'm going to take 5 minutes, if that's fine, and then wrap right here. So in terms of looking at the economic rights, making copies, that is where you have mechanical royalties emanating from. So that reproduction rights, every time a copy is made of the recording, every single copy that is made, then mechanical royalties is generated, right? And there's a mechanism for that for those royalties to flow. So typically, of course, the record company that is pressing or making these copies, they would have gotten permission from the writers and composers for that to happen. And a portion of that money that is from the sales goes towards songwriters and composers. So mechanical royalties goes to songwriters, composers, and their publishers after each copy is sold. So when a song is even downloaded or streamed or a CD sold, if a unit is sold for, say, $1, for instance, if one recording is sold for $1, typically about several years ago in the US, it was about 9.1 cents. It has actually gone up to, I think, about 15 cents or thereabouts, being the mechanical royalty share from that sum that it is sold for. And that's by US law. There's a specific amount that's earmarked from every unit sold. And that is then split between the songwriters and composers, right? Public performance, right? That is where performing and performance royalties come from. It's played in public, whether live or recorded. Broadcasting, performance royalties emanate from that. And when you do an adaptation, sampling and so forth, direct royalties. Online, performing and mechanical royalties. Rushing a bit. On the master rights side, when that copy is sold, so it's the same copy that's being sold, it is typically called sales royalties, and that goes to the record company, record producer. Whereas the share that goes to the songwriters, composers is called the mechanical royalties. So same source of monies, but it's called something slightly different depending on who it's heading to. Right? So for the public performance share for producers or master rights owners, it's called performance royalties. Whereas for the songwriters, composers, it's called the performing royalties. Right? Likewise for broadcasting and so forth, right? And of course for the artists and musicians, funnily enough, when the copies are made, they do not get a direct flow of royalties from those distributors or retailers. No, the artist does not, nor the musicians. So sometimes you'll hear an artist say, Spotify they're not getting any money from Spotify, or Spotify not paying a lot of money to artists. The truth is, Spotify does not deal directly with artists. The term artist is used quite generally when you hear it used in that sense. But in terms of the vocalists, if we're referring to the artist as a vocalist, they are not entitled to any direct payment from those distributors. It is the record label typically, or the master rights owner, the producer, who has made those recordings available for sale that gets paid. And the artist would then have an arrangement with the producer or the label. So you record for a producer, you record for a label, and you have an arrangement with that producer or the label to say when a copy is sold, then as the artist, I'm to get a certain share. So when the copy is then sold, his share, meaning the artist's share, is called the artist royalties, right? So the label share is called the sales royalties, the songwriter share is called mechanical, but the artist share is called artist royalties. And that comes to him or her via the record label or the producer once there is that agreement in place. Similarly for public performance and broadcasting, the artist only gets paid when the recorded music is used. If he performs live, then the arrangement between himself and the promoter, that's entirely different. He gets paid a fee to entertain on stage. But in terms of his live performance, there's nothing that flows from the performer or from the promoter to jams for that performer, right? Only if he's a songwriter, then something flows to him in his capacity as a songwriter. And similar thing obtains for broadcasting, right? So I'm going to wrap here. But suffice to say, though, that the world of music, it's vast, it's complex, but it's a huge business. And so, for instance, this year, the report that just came out, the Global Music Report, the market is now structured in such a way that about 62% of the revenues generated internationally from recorded music use, 62% of that is via streaming. About 19.5% is from physical sales. So CDs are still selling in some places. In fact, Japan and South Korea are still huge consumers of physical copies, huge consumers, right? And so 19.5% of that is physical, which includes vinyl. Vinyl is still selling. In fact, it's doing quite well these days. And then we have about 2-point-something% for synchronization, about 5-point-something% for downloads. So downloads is almost a dead market. So, you know, iTunes was leading that chart many years ago. You'd go and download your copy and you listen to it whenever you want to. That has entirely, it's almost gone. It's now about streaming. You listen on demand. You do not have a copy to go back to on your laptop or your phone. You don't have a copy anymore for yourself. It's all about streaming. Unless you're going to go into the physical market and now buy CD once more and buy your vinyl and so forth. So in a nutshell, you know, these are the areas within the realm of music that you make money from and how the rights actually come together for that to be possible, right? So Aidan, I'm going to throw back to you. I'm certainly be able to take questions. I think I might have jumped across a few areas, which I'm sure there may be questions on, but I'll be able to and willing to assist with some responses.
Thank you for presenting, Mr. Mullins. When you asked, I'm sorry, there's a little bit of echo.
By the way, if I have more time, please let me know, because I could keep going on, you know.
Unfortunately, we're a bit strapped for time because now it's time to do a Q&A panel and discussion. So the attendees do have the option that they can either enter by the Q&A feature, or if they want to use if they want to raise their hand, and we'll allow them to talk, to ask any questions pertaining to either Jam Copy or Jam Society. And if not, then I guess we could come to a conclusion. But does anyone have any questions to these two companies? Because this is the chance to talk to the general manager of Jam Society and Jam Copy. So I would definitely inquire you to use this option right now. So does anyone are curious about anything regarding intellectual property, or did they just cover all the bases? Let me know. Okay, so Najali Smith, I don't know if I said that properly, but she asked, would you represent a producer / songwriter / composer? I'm guessing that's for jams.
Okay, I think it says who would. So in the Jamaican context, right, thanks. In the Jamaican context, jams represents the record producer and the performer. So if you're a record producer, as an individual, you can join jams. If you are a record label, then you can join jams in that capacity as a producer of records, of music. If you are a songwriter, you would head on over to Jacob. Songwriters and composers, so the authors, they go over to Jacob. So Jacob handles copyrights. So they're covering the authors, songwriters, composers. Jams handles producers and performers. I hope that distinction is a bit clearer. Jams is producers and performers. Jacob is songwriters and composers. And this obtains in pretty much in most markets. So in the UK, you'll have PRS, which is equivalent to JCAP, songwriters, composers. You have PPL, producers and performers, just like jams. And you continue over into Germany and Japan, and so in most markets, that's the kind of split that you have, where there's one designated body representing producers and performers, and another representing songwriters, composers. But I did mention that in a few markets, such as Trinidad, you may have one entity representing everybody. Same thing over in Barbados also.
Okay, thank you. Roxanne Lawrence said, which form should one use to be a member of JAMS?
Okay, so if you're a producer, there's a minimum requirement to be met. You have to have at least 3 sound recordings that you've produced and which have been released commercially. Meaning that if as a consumer, I want to purchase your recording, I must be able to find that somewhere to purchase, whether in a store or online. So that's a commercial release that we talk about, not just a promotional release. So you may produce a song and you decide to throw it up on YouTube. That's a promotional release. You may decide to send it straight to the radio station. That's a promotional release. But making it available for sale is a commercial release, and that is a minimum standard that must be met for jams, a minimum of 3. And in terms of the forms, they're pretty basic, really. An application form and a membership agreement must be signed with us. Those are available on our website, or you can call and we'll shoot you an email with that. If you're a performer, the requirement is slightly different. If you're a performer, you need to have at least 10 recordings that you have performed on. So you're either the singer, the DJ, or you're an instrumentalist, you're a drummer, you're whatever, you're a musician. You must appear on at least 10 sound recordings. If, however, you cannot provide 10, but you can show that at least you have appeared on at least one song, one recording that has gotten or is getting, is playlisted in a major market, then you can provide that evidence to us and we can begin the process of representation. So it's either 10 that you have released commercially or part of commercially, or at least one that you can prove is already active in the major markets. That's for performers.
Okay, and Najali had a follow-up question before that. She said, what if, or he said, what if all 3 is one person? So a singer, songwriter, and composer.
That's easy, and that's a beautiful situation for that person to have, because it simply means that you're a songwriter, you're a composer, you're a producer, a performer. It simply means that you then have all of these rights, these exclusive rights, which you can monetize. You have economic rights available to you for all 3, in all 3 capacity. You can then join jams in your capacity as a producer and the artist, meaning the performer, and you can head on over to JCAP and register as a songwriter or composer. And so these are different rights that exist, and you're able to benefit from them by these different avenues. So if you're 1 in 3 and 3 in 1, you have available to you multiple streams of royalties through different organizations.
Okay, and this one is I'm going to regard it more than likely is for Jam Copy. If you have information on this, from anonymous and attendee, the question is, how do I protect software that I have written?
Right, I can handle that. It's not going to be in a written form, so it's a digital work, but the same principle applies, which is to make sure that it is labeled indicating the author of the work, the owner of the work. So you have digital rights management tools where you would imprint on the work name, date of creation, and the copyright symbol. But then after that, it's taking the necessary precautions. Where is your work being used? Where is it being made available? Are you going to license the use of the software? So you would need to have a license, which is a legal agreement, a contract, setting out the terms and conditions, under which the software may be used and whether there is any remuneration or payment for the use of the work, and also applying any digital locks, sorry, so that it can't be easily accessed and then copied without the permission of the owner of the work. If I may, I have a question for Evan. In light
Sure.
of those stats that you had about where the majority of money is coming in, if downloads is declining, but streaming is the dominant force, what are the incidents of infringement with streaming, if there are any?
Well, it's actually probably not as high as when we were largely operating in the realm of CDs and so forth. If you're talking about infringement, right?
Right.
That's much easier to detect, of course, in terms of physical copies and so forth. In terms of streaming, there is still that element of, I cannot put a figure on it or rate at which is happening, but it still happens. And generally, in terms of a context, you may have someone who is not the rightful owner of he's not the rightful owner of the right to distribute or the right to make copies. They will sometimes deliberately or inadvertently present themselves and the work to a distributor to be placed on the market. And so vigilance is required by the actual original owner, the producer, the author of the master, to identify when this happens, and then, of course, issue some kind of takedown notice via the distributors for that to be removed and the appropriate credits attributed to it if they want it to remain, or if they want to take it down and release it on their own label. So it's 1 second for me. I think I'm getting a battery. 1 second. So I cannot, unfortunately, give you an incidence of that happening at the moment. I can find that out for you. But there are much greater controls, though, in the streaming realm in terms of infringements, right? And quicker action can be taken in the streaming realm.
Okay. Well, that was an amazing question, Ms. Davis. So Roxanne John Copy, this question is to John Copy. Roxanne Lawrence. Najali Smith has a third question for you, by the way, Mr. Mullins, but we get to that in a sec. So Roxanne Lawrence said, as a writer and author, which form do I sign up to apply for membership with? She said JCAP, but I'm pretty sure she meant JCAP.
Well, just in case she meant JCAP, but there's only an A missing from there. The process is similar for JCAP and JAMS and Jam Copy. We have the affiliation agreements or membership agreements on our website, but you can also come physically to our locations. And for us at Jam Copy, you would need to bring a sample of your work that has been published and is available on the market. So just as for Jams, you need to have works that are out there available to the public and that are being played. For us, you need to have at least one work that is published and available to the public, whether it's the bookstores or on Amazon, it's being used in schools. We need to have evidence that your work has actually been published and is available to the public. And you would fill out our application form, and we would then go through our internal verification processes. And if I may just preempt Jams with that question about a fee to join, there is no fee to join for us. I don't think there's a fee for joining for you either.
No, there is not.
Right. So there's no fee to join, but we are acting on your behalf to collect royalties and to pay those over to you. It does mean, though, that when we collect the license fees, we would have to deduct a certain percentage to cover our operating costs before then paying over the royalties to our affiliates.
Just to add a little more to that, I happen to know that JCAP, they do charge a registration fee. Jams Over does not, but so JCAP does. I can't quote you that fee, so you'd probably have to contact them directly to find out. But the processes are quite similar in terms of application. In our case, you present with a passport size photo proof of the commercial release, you complete the forms. We then do our due diligence and verify that, in fact, you say you own the rights to these. We do certain levels of due diligence and background checks to kind of cross-check the information that is being presented to us to ensure that we are in fact representing the rightful owner of the work, right? In terms of fees, so no fee for us, but just as Philippa said, we do deduct from what we earn as a licensing income. We do deduct administrative costs. For revenues that flow from overseas to us, that is basically passed on as is, say for 7% fee that we deduct to cover the work involved in that huge undertaking to deal with our counterparts in other countries. It's really and truly a lot of work to engage Germany and France and US and UK. A lot of work is involved in that process, especially when you have overlapping claims, just to help get some of those resolved. And so we think 7% is a fairly reasonable sum for all of the work that is involved for that level of administration. So just to make that clear that yes, from overseas royalties, we do deduct a 7% sum as a fee for the work involved.
Okay. Someone indicated by the hand gesture that they wanted to talk, but it doesn't seem like, it seems like that was an accident. Oh, wait, actually, that's not a mistake. Okay. Okay, okay, Miss Portia, you may speak. What's the question that you wanted to ask? Miss Treasure?
Good?
Huh. I gave her the ability. It looks like she's not unmuting. Okay. All right. That's great. I do have one. I am interested about one thing, Mr. Mullins, and this is from my perspective, because obviously, I had to make sure that I'm very aware of the topic at hand to at least help out everyone here. I did like a small bit of research, and I did see a recent uh, interview with uh, with a company, and they did ask a question, and I always wanted to and I always wanted to wonder myself. This is a variation of that question. Oh, Miss Treasure.
I'm just checking. Are you hearing me?
We can hear you, but you're very laggy, to say it, put it like that.
I won't be able to do any adjustment because I'm actually driving. So I guess I will have to call the office and get my.
Actually, no, we can hear you properly now. Can you please ask the question?
Okay, so someone who has used a distributor to well, I have released a song through a distributor, one of those online distributors is there any conflict? Is there any, how does that work with Jake? Would you be able to collect the royalties or whatever through Jacob Jams? How does that work if you use a distributor? Because I had to commercially launch the song through the distributor first, even before I can any of those Jams or Jacob. If my question is.
I can to reiterate the question properly.
Sure.
She said that she made a song and sent it. She made the song and published it through a distributor. She published the song through a distributor, and she's wondering if there's any sort of conflict.
The economic rights that we spoke about earlier, some of those rights are retained by the rights owner, and some of those rights can be transferred to the collecting societies, such as Jams and Jacob. So specifically speaking, the right to make copies and the right to distribute, those rights are held back and kept by the rights owner, which then enables them to go to a distributor or to a manufacturer, etc., to negotiate deals directly. And so if you have recorded a song, you own the master, and you've actually gone ahead and found a distributor, then the royalties which would be flowing, or the revenues flowing from the sales or the downloads or the streaming of that record would be coming by the route of the distributor all the way back through to you. So the distributor would be obligated to you to pay you directly. Those funds do not come to the collecting societies from your downloads and your Spotify streams and so forth, or your Amazon sales. Those go back to from the end retailers to your distributor, who then pays it over directly to you. In terms of whether there's a conflict, so no, you first have to make your content available, which you have done beautifully. It's available for sale, nice. And then you can also now come to Jams because you do have other rights. You have public performance rights still in hand, and you have the broadcasting rights still in hand. You know, come to Jams if you're the producer and you're the performer, and you say, look, listen, I'd love for you now to handle these rights for me because I can't go to every party. I can't go to every radio station to handle these rights on my own behalf. So that is where Jams comes in, and Jacob. And we then are able to negotiate and collect royalties for you now when the songs are played. When the songs are played on radio or on TV or in the hotels and so forth, or the clubs, broadcasting and public performance, we cover those rights for you, right? On the side of Jacob, they would do the same. So if you happen to be the songwriter, you can also head on over to Jacob. So you come to Jams as a producer and performer, you head on over to Jacob as a songwriter or the composer, and Jacob does the same thing on your behalf. So in your case, it sounds as if you are the owner of multiple rights, right? May or may not be. But if you are, you would then be able to do all of that without it being a conflict with the distribution end. There's no conflict between what we do and what the distributor does. They are separate rights that have been passed on to the different entities. So no conflict there at all.
Okay, and that's an amazing answer. And that was the question that I was planning on asking you, by the way, Mr. Mullins. Okay. So Michaela Green asked 2 questions. The first one is, excellent presentation so far. Thank you. You're welcome. My question is, what is the process when someone has breached their intellectual property rights and you need to collect royalties? Do I notify Jacob/Jaipal? What is the process? And I'm presuming that is for a jam copy.
So first of all, Michaela, remember that intellectual property rights is the broad area of law that protects creative expressions in different forms. And then we have different types of intellectual property rights. So it depends which type of intellectual property right, whether it's trademarks, whether it's patents, whether it's copyright. But let's say it's copyright. Somebody has copied your article without your permission, what do you do next? Well, because the intellectual property rights, including copyright, are private rights, meaning that you as the author / owner own these rights, you would be the first person to take action. So perhaps maybe you could engage a lawyer to write whoever has used your work without your permission and to ask that they cease and desist immediately. And if they have commercialized your work without your permission, you would want to get the money that they have earned without your permission. You would want an account of the profits and for those to be paid over to you. And so engaging a lawyer would be a good step. If, for example, now, as we have seen in Halfway Tree and other places where people have made mass copies of exam papers or CDs or DVDs, then the police can be engaged, because that could now become a criminal action where that person would be charged for piracy. But you could also at the same time take a civil action to recover any profits that they have made from all those copies that they've made without your permission. So there are different steps that can be taken, legal action certainly, but it would begin with you as the author or the owner who has the private right. It wouldn't be JIPO, which is a government agency, and a JAM copy or a JAMS or JCAP may be brought in to give evidence that you have joined that CMO as a member, or maybe to give evidence that this is a work that has been played on air and the payments and have been paid over to you by them, the royalties have been paid over by you, but it would initiate, the action would initiate with you as the owner of the work.
Oh, okay. And there's a follow-up question. This is either JAMS or JAM copy, whoever wants to answer it. The question is, what if you heard that someone has breached their rights, but you are not actually there to witness the breach? And she said live performance, so I'm presuming JAMS.
It's a sort of vague question, because I'm not sure what work you're referring to, actually, what work you're referring to, Michaela. Is it, for instance, that you have recorded your song and released it, and someone has now gone ahead and performed your song live on stage? For sort of like you're doing a cover of your music in a live format. Is that what you mean? Well,
yes,
she's saying that
that's exactly what I was referring to. So if somebody has performed your song, this is a song that you wrote, and you weren't actually there at the event, but you heard, or maybe somebody recorded it. Is it that the next step is to come approach JAMS, or what's the process?
Okay. All right. Really good question, actually. So I'm going to split it into two parts for you. So where JAMS is concerned, we wouldn't be the one to step into that breach to act on your behalf. Okay, you mentioned now a live performance. JAMS, our remit is to deal with the use of the recorded work when the recorded work is played at that event, not a live performance by an artist. So we would not have granted that event organizer a license, nor or in a position to grant them one for the live performances. However, JCAP, would be in a position to probably assist you. And it would depend, however, on whether or not you are a member of JCAP. So if you're a writer and you are a member of JCAP, then certainly JCAP has a role to play there to assist you quite well, because that event organizer certainly would have needed a license or permit from JCAP in order for these live performances to take place. And if your work happened to have been one of those which was performed live, then the permit that was granted by JCAP to that promoter of the event would result in some of the fees that were collected from that promoter to be passed on to you as royalties for the use of your work. So all is not lost, and you wouldn't have to necessarily reach out to a lawyer immediately. If you are a member of an author society, and if it's in Jamaica and you're a member of JCAP, or even if you're a member of an international bodies such as a BMI or ASCAP or PRS, they have affiliation to JCAP here. So even via that route, if that song was performed live on stage, you'd still be protected via JCAP, who would have or would be responsible for granting permission for that event to take place, for live performances to take place. If, however, you are not a member of any licensing body, any collecting society, then, and that breach happened, then certainly you'd want to then, as Philippa mentioned, engage the services of an attorney to then begin the pursuit of remedy for that unauthorized use of your work. So by that means, you'd be able to probably get some remedy directly from the event organizer, and possibly also from the person, the artist who used your work without permission, right? I'm not sure if Philippa wants to add anything to that, but those two avenues will be available to you depending on whether or not you are a member of collecting society or not.
Yes, thanks so much, Evelyn. I appreciate that. And Michaela, it could be also that if you want the person to continue to use your work, so for example, the article I said, if you want that institution or that entity to continue making limited copies of the work, you could then direct them to a jam copy. Or if it's music, direct them to the jams or JCAP so that they can then get a license and legally make copies, legally make use of the work, and your royalties will be remitted to you thereby. But if it is egregious, their use of the work, and you would want to completely stop them, then legal action would be a route. But if you wanted the relationship to continue, but legally so, then you could direct them to the CMO and even approach us for us to approach them on your behalf, and then to initiate that legal relationship.
Well, thank you so much, both of you. Very helpful. Thank you.
And I mean, yeah, thank you so much, Jams and Jam Copy, for answering all those questions. You know, those are. I said it at the start. This is a good best time as any to directly talk to the general managers of these companies to get all the inquiries. And as you can see, there's a lot of people that are interested in doing it, and which is good, because you know everyone needs to know that what they put out into the world is something that like shouldn't be like used inappropriately or in any way, shape, or form. Which is becoming a commonality. Unfortunately, it's slowly becoming a commonality of people misrepresenting, misusing works without permissions and stuff like that. So I really would like to thank the Jamaica Music Society, Mr. Yvonne Mullins. I'll also love to thank Miss Philippa Davis from the Jamaican Copyright Licensing Agency for attending, presenting, answering your questions, having panel discussions with you all. This has been a very eye-opening session. And now all of these budding companies can now use your services to ensure that their work is definitely accounted for in the world. Okay, so yeah, thanks to both of you, and
Thank you, and all the best to your attendees.
yeah. Yeah, and both of you, I hope you have a great day.
All the best. Thanks for having me on. And certainly all of your attendees can feel free, if you are involved in this business as a performer, as an artist, as a musician, or as a producer. And if you know anyone, then certainly you can feel free to direct them to Jams for representation That's what we're here for. That's what we do. That's what we do daily. That's what we breathe. That's what we live. And we think we do it very well for hundreds and hundreds and hundreds, thousands of Jamaican creators and owners. That's what we do. And we can do that for you or those that you know who are not yet represented. So all the best to you and your attendees.